say can Agyapong ye buano aten and I buano aten.
Okay, I think say the kind I don't know if you trigger na for if you say when say ya tumwa mu semno ya kofi semno sa senko tota you find me no e fa so bu aten the kind of say dia otomo for no for bet na say no afa Ghana mpa nchihye ya ye be fa so bu aten na bu aten and I say obefa aboafo na for mu jury na for so adobo na so say ye so jury na the more for one and matches on chair or acquire or more fossil efficiency move. It is the evidence that to any man, quite a more fossil, my church in be much and remembering I also also with a court I can dream family now. Nothing, man, show him to say. And there's more from that show Omundi Subiano, and also with this of Pepe. It was more for me, yes, idea will be now. As some of the Canada's issue, US court, no, we use jury system, no, and no, more for the match, movie, now, yeah, a more Casa, more, I know what their court, no, I had the verdict, and no, the more for me, Hoshe, now, almost, and over the back. And so, it's important to say, the case distinction, now, yeah. Say you and in the decision by man and verdict bar and yet conclusive enough. So jury no econo for ginger and no banos you and some are caught in the my shame I gave from one in safety. I guess a court no fast assembly now Bonnie Becker or internal as a decision or a judgment of the court. Court no fast adoption. Also court no just assembly. No court man kasa it seems so say we na ye muaya court no e dey bible thing. In such matters the court necessarily has to take the verdict and enter it as a decision of the court or a judgment of the court. Anything short of this via every judgment. It say we pay attention to some of the arguments I know on social media. What is that from Sakoko aside? The post of a lot of conversation. He was very specific, saying the jury in the SS court has awarded a verdict of 18 million against Agyapong. One can say the court has awarded a judgment of. In sometimes I think that those distinctions are key. And there he has said, there is no judgment against Agyapong. Legally speaking, there is no judgment against him. Now, the US laws say, yeah, what these damages against we are both say, what can do this or can not, we can say, could change to be poor. There is this legal principle I find remedy so. And what you say, your both how a quarter, and man of my whole point says, we did this as I can with a bullish soon far. Who cannot catch a court and say, the idea to me so idiot. I say, no, solution of a taboo, I can soon a jack. To the mother will do one session money. Court meet nation, no one should share and say, no shine. The entire my US for this principle, by any say, no, your case in the normal system where you have a judge sitting on the case. He is guided by the rules of law, the facts, and all legal principles. But in a jury system, the jurors are not necessarily making their decision based on the rules of law or the specific provisions of law. For example, say if they are judge or making an award against Obi for that act, or they make specific awards, for example, if they are for the road traffic offense, causing harm to other road users and everything, and running saying a 20,000 penalty and a 100 penalty unit. Penalty that could be a 12 cities. So he will multiply that by that. But a jury can make some decisions no matter how outrageous they are. And at the end of the day, the whole jury system is built around the perception that jurors may afford every until they represent the larger society. into their feelings are that of the larger society. And sometimes they may go overboard kakra. So for example, when a judge is bidding command, they'll tell you there was this case, book case, I think it happened in Ashanti region, and near 4 million and about a kubako. So it's a murder case. Fact, you say a murder case. Now, judge no every jury now call you the expectation is that they will come up with a guilty verdict. But the star witness in the case is Mammy the mountain family. And somehow or catch a jury and say, we say about time we bay or condemn when initially. It is not that the boy has not committed murder, but the woman is appealing to the emotions of the jurors. And jury system, we say, oh dear, you know how to appeal to the emotions of jurors. Oftentimes, you can have a decision going your way. It's Mamia, but now the Baba Kun, the Kofi Ahon and the customer. If it's a matter before a judge will decide here. The judge will go strictly according to what the law says. Section 29, Section 30, and then Omokapa Medaho and sentence again, life imprisonment, death sentence, whatever it is. That is what the judge will do. But a jury has to now come up and say the person is guilty or not guilty. Or someone will have a decision that judge is leaving who should be. And they are not making that decision necessarily on rules of law. At best, they will do so based on the facts available. If we are not a jury system, sometimes, example, the U.S. court, any journalist who goes to a U.S. court for defamation is likely to win, dependent on the kind of arguments that the person makes. If the arguments made in the U.S. court, he created the impression that in Ghana, some people are above the law, especially politicians. This is a statement that will appeal to every single juror in the United States or any part of the Western world, whether it is true or not. Because I mean, we're all here when even President Trump was held before legal processes and all of that. So who go before a jury, you have the chance to, you can even be manipulated and get away with it. Jurors are sentimental. It is all profile jurors who say, we have neighbor, we Christian, we say, you know how to play with your arguments to get them to give you the kind of.
But George, and no dear, more na more yellow who obviously, some quarter. You can't so be making an argument, but superior arguments in the Bewini. I'm sure, sir. Agyapong Nankasa, it's me the necessity in the book and said, me, Biwusika, I'm going to pick the best lawyers, underline, best lawyers. I'm very sure, sir, the best lawyers now, Agyapong Jew Mudino. Omunim, all those things say, they are, during the say it, so one was in here, because honestly, I'm saying this because the Amma excitement in Nabano may not be necessary because of Agyapong, but there are excitement to me, be a quiet to say, Anke Ghana ha, Kebe frustrated system na ma wan showing Ghana, say Nipa no kwa would be man na Udifa, na ko problem. And a case study could be, Yemfani say, JB Dankwa MP. Look how many years in ye. Yentiminya, but they are not a butcher. Kati na asebe mu se odi fo na se odi bem obi betime de na sama kokko ha ni a frustrating na ye nyina ya victim pay ye be frustrating na fe no se nyakra na ye betio. Is it not something that yes, at least your court system no, we need to work on that?
No, I think that comparison is a wrong one. First and foremost, in fact a jury case and compare a street case where it is an indictment proceeding. A wrong comparison. The motives are very, very different. I have to say, I say, will be a percent of compare a radio show host by his ability to write. It's not necessarily the same. Now, Obama Bashir, the kind of And the example you made, the JB Danko example, let's even stick with that example. It is a murder case. Doing a murder case in Ghana, doing a murder case in US, there are things that would help you. But generally, there are some principles that would guide you. Every murder case, there are two ways of assessing evidence. There is what we call the preponderance of probability and a balance of probability. So, you are putting things together to suggest that there is a likelihood something happened, or there is a likelihood that something did not happen. So you can say, oh, the big church say idea by and also answer. But you are calling it a murder. It comes under what you call proof beyond reasonable doubt. And also to share evidence so you cannot compare these two situations. Now you get back to even the jury process. Now I mentioned earlier, say the judge or the court instructs the jury on exactly what to do. If the jury in any way deviates from that specific instruction, it becomes a ground for mistrial, which is one of the contending issues before the court now. Now, court, Emma, jury, a human answer, say, first and foremost, the jury was supposed to decide, say, in Agyapong, were you guilty and are you guilty of the issues that have been brought before the court. Now, the second thing the jury was supposed to do is say, so one will say, or you guilty, yeah, then we should assess actual damage. Actual damages are in Germany. Beyond that, you should also assess defamatory damages. Now, no one may say in a court with the man with all yet. The court sets a different base. So, Baba Bishia to come and assess what we call punitive damages. Punitive damages means say, assessment, was it of an aggravated nature? Maybe an abroad, so the panel, or they could do the against, or they could do an abibisa. Court, a bar. As a case of punitive damages. The jury now, so the court asks the jury, says, on this you are to assess punitive damages. The jury now says that, oh, the OCA, now on the Friday, last Friday, he has said, actual damages at $10 million, compensatory damage at $5 million, and punitive damages at $8 million. Meaning, I'll cover one about $18 million. And then, the defense counsel can raise the issue that this is grounds for mistrial because instructional court with the jury, it appears that Omojuma is now, if you listen to the video now circulating now, the judge in acknowledging the verdict of the jury indicated that he was going to. And before that, he had mentioned that he will not take oral submission for this trial. He will say offer for submission. If you are the one on the can, if you also are, when the judge feels that the matters are weightier, the better choice to come on the record. You have to come with a written submission or written motion. The judge told them, say, on the issue of this trial, he was not going to entertain an oral submission. So the parties should come with a written submission. And then the opposed lawyers have taken steps to file the written submission. Now, when that is done, court will 30 days to determine the issue of mistrial. Two things are going to happen.